Hi, my name is Faith Nouri. I'm an attorney. I practice family law, divorce, and immigration, US and Canada, in Huntington Beach in Orange County, California. Today, I want to speak with you about what is mediation. Mediation is a format in order for you, a party who's going through dissolution um, or any other dispute that you may have, to try to resolve it by speaking with the other party through a mediator, or you can actually have representation in order to resolve your disputes without the need to go to court and make a formal request for orders from judicial officers. Who is a mediator? A mediator is a person who's trained and has experience, has done hopefully a number of mediation, and is able to mediate for both of you. Somebody who hopefully is not judgmental, it doesn't run by their own belief system of what it should be right and what is wrong, and try to suggest that or impose that at times. Mediation is it requires a person who really be even-handed. So I have seen a lot of agreements where parties come to me and say, the mediator, said this is the best offer for me. I'm very lucky to get this offer, that my ex is giving me this and all, and I'm looking at it and it's quite unfair, and the way it's drafted is unfair. It happens. Unfortunately, that happens more than I would like to say. The evidence code protects the mediator, so the mediator is protected from being really questioned as to what happened during the mediation. So any communication that takes place during the mediation is protected by evidence code. So a savvy party can use a mediation to get a very unfair result through a mediator who is, again, through that process. As long as everything financially is disclosed and all the documents are presented correctly, it doesn't matter if you are agreeing to something based on your belief system or what you were fed, that this was a right amount or right division or equitable community, and it wasn't. That could happen and happens quite often, I have to say. It is not something I like to see as a mediator, but I do see it. And I always tell clients, use your common sense. If you are doing a mediation and you agree on terms, take that to somebody else, an independent attorney, to review it to make sure you are okay with that agreement, and have the attorney explain every provision. So what does it mean when I say that I've received GAVR and warning for my support payments? What does that mean? What kind of a consequences this has? When it says this is a final custody order, what does this mean? And what does this wording has for me, or it does for me? Go to an attorney and spend a couple of hours, ask them to explain every provision, the legal ramification that it has for you, so you make sure you are not falling into a trap per se. And I have to say, the whole idea for mediation is for parties to be able to reach an amicable resolution. But at the same time, it can be used as a sword and shield for the other party. So make sure you are not in that dynamic. The other thing is, how can you protect yourself? Protecting yourself is, one way is to get an attorney. You can mediate still and have your own attorney with you at the mediation, so your attorney knows the legal issues and will help you. But you don't want to get somebody who just focus on litigation to mediation, because they only do a litigation, so they're like a bulldog and they can't really distinguish or are unable to really change gear that fast. If a person is trained mediator, even if they do litigation like what I do, but I still am able to change gear very quickly, because I am doing both areas, and then able to um, discuss the provisions, go over the provision, and actually, while trying to reach an agreement, and always reach an agreement, is to basically make sure the client is safeguarded and the provisions are fair, and it's in accordance to the law. There are times parties can give their rights away. Let's say I've had cases when one party wants to give the house to the other party. That's perfectly okay. You all have your prerogative to do what you want with your assets and debts. This is your right. So whatever you wish to do. So nobody should be telling you can't do that. As long as you understand what the family law and family code says, and you are still proceeding with what you would like to do, it's perfectly okay. Knowledge is power. Just understand what it is. So once you understand it, then you can make better decisions, what is called informed decisions, okay? Can you co-mediate? I suggest that a lot to clients. Let's say I have clients who coming in, or I have mediation where I see parties have a lot of issues, financial issues. One of them is self-employed, And that creates a problem because the other party usually is a stay-home parent, has no idea, or maybe working for a company, MBA W-2 wage earners, has no idea what the other party is earning because they're self-employed. So when they are separated, it creates a problem as to whether the income that is being reported is their accurate income. So get a joint forensic and have the person go over the cash flow and tell you what the earnings are for for that year or for each month, so you have an idea that you are making the right decision. So you are not entering into an agreement thinking, well, one of you thinks that you're doing a favor to the other one, and the other one thinks maybe that, I'm just being taken advantage, but I'm just going to let it be. No, don't do that, because you both are going to resent it. So the best thing is to be informed, to know what your rights are. If you decide to deviate from that, that's your choice, but understand what you're deviating from. Sometimes we have custodies where parties are unable to negotiate as to parenting time. I see a lot of parties say, I want 50-50, I want 50-50. Well, okay, that's fine. But you can't really divide. It's not a cake to cut it in half and be 50% and 50% you. The issue is really who is able to provide a better care and custody during the time they have their custody of the children. So let's say if a party is never home and drop the kids at aunts or cousins or uncle, and they're never really there, and the other parent is available and can take care of the kids, really, who do you do favor? It's just based on why are you asking for that, unless the issue is a position and maybe support issue that you're going to be paying. So the whole idea is what is best for the kids. The issue is not that the uncle or aunt is not good to be around the children. The issue is parties, the parents are the custodial parents. So when the goal is to spend time with your child, then you need to spend time with your child. I understand we all have to work, so we all work, so we all are going to have babysitters and caregivers. But that's completely aside from what I'm talking about. So think about what plan works for you and your child or children, and then try to reach an amicable resolution that serves your family. It's not about, I'm not going to let this party win if I give them X amount of time with the child. The parenting is not winning. Parenting, you just raise the children the best you can, and you hope to provide a good and safe and lovely environment for your children. So work at providing that environment for your children. If you have a parent who is doing a great job with the kids and you are more entangled with your life, with your job, with your other partner, or with other children that you may have, then it's okay to let go and let that parent be more in caregiving, more involved in the caregiving of the children, as long as the other parent can and is willing and want to. So basically, you're trying to find what is best for your family, and that's the bottom line. It's not about who wins, because when you are separating, you both are going through an experience that you had. You shared life together. You probably had children at times. So the issue is not who was wrong, who is right, and who damaged me or was unfair to me or betrayed me or lied to me. The issue is, how am I going to go now from where I was to where I want to be, which is to be single or to be in a different relationship and being able to continue my life in a pleasant way that I would like to. So that's basically what I would like to let you know. So co-parenting helps. So at times we would engage child psychologists or parties that have more knowledge about custody and would get them involved. Of course I do too, but a lot of times it helps to have a third party too involved, and they parties can go and discuss that with them. And sometimes if children are older, they can discuss with the mediator too, and a child therapist, and they can say what they want, as long as they're not influenced and they have not been their loyalty is not in such a way that they're making decisions or expressing their opinion based on guilt and shame. So that said, I hope this segment is helpful to you, and I will have more segment providing information, and I hope that would be helpful as you go along in resolving your dispute. Thank you, and have a good day.